Good afternoon, everyone. Debbie Hart, the President and CEO of BioNJ. I'd like to welcome you to our first IT cybersecurity briefing of 2025. In fact, our first briefing of 2025. Thank you for joining us for this timely program. Today, our panel of experts is going to dive into how cybersecurity risks are shaping the life sciences industry, from cyber insurance and data security and more. As companies continue to innovate and bring groundbreaking therapies and products to market, staying ahead of rapidly evolving cybersecurity regulations and threats is just more important than ever. With a lot to cover, today's program will go until 1:15, just so you're aware. Special shout out to our hardworking planning committee who brought this program forward. Thank you to today's program sponsors, Mercer Marsh, McCarter and English, and Verve Group Consulting. Today's webinar is being recorded, will be available tomorrow on bionj.org. And we do expect a number of people in the room. We have quite a few already. So we'll try to get to as many questions as possible at the end of the panel or even during the panel. So if you have a question, please type them in the Q&A box. If we don't get to your question, we will follow up with you after the program. So now we will get started. Regrettably, due to late-breaking changes in policy at HHS, Daniel Burke of the FDA is unable to join us this afternoon. He extends his sincere apologies for the last-minute notice, and obviously that's an evolving situation. We will remains to be seen exactly how it will go from here. We hope that we will be able to enjoy the participation of FDA and other government speakers in the future. We are fortunate to have an outstanding panel of experts with us today, nonetheless. To introduce our panel and guide the discussion, please welcome co-founder and managing director of Verve Group Consulting, Larry Samelo. Welcome, Larry.
Thank you so much, Debbie, and thank you to our panelists and all of our attendees. You know, the headline today is that for all life sciences companies, having proper cybersecurity hygiene is really no longer just a low priority. It really is, and this is true for even pre-revenue and early revenue companies. Having proper cybersecurity hygiene is now recognized as a very high priority must-have investment in a company's overall reputation, and in particular, the trustworthiness that companies earn with their patients, regulators, and investors. So in terms of what we're going to hear today, we're going to hear from some fantastic experts who will help us kind of understand what good and proper cybersecurity hygiene is. To kick it off, let's get it started with our friends from Marsh, and I'm going to turn it over to Catherine Clark from Marsh first.
Thanks, Larry. Good afternoon, everyone. My name is Catherine Clark. I'm a vice president and cyber insurance broker within the Northeast Zone for Marsh. In my role, I have the opportunity to work with insureds from a number of different industry classifications, including life sciences, to help navigate the complexities of cyber risk management. I'm looking forward to a productive discussion today, and thank you so much to BioNJ for hosting.
Perfect. My name is Shane Moylan. I am also a vice president within Marsh's cyber insurance practice and a cyber insurance broker. I also am the life science cyber industry specialist, meaning I aid clients throughout the country in identifying, measuring, and navigating the complex environment that is cyber risk today within the life science industry.
And finally, to round out the panelists, my name is Scott Frickley. I'm a partner at the law firm of McCarter and English. I focus on data privacy issues, both counseling and litigation, and I also do intellectual property litigation as well, patent infringement, trademark infringement, and the like. It's great to speak to you all, and BioNJ should be commended for being able to bring us all together today.
Great, thank you, everyone. Okay, without further ado, we're going to have our friends at Marsh kick off the webinar. So I'll turn it over to Catherine and Shane.
Thanks, Larry. We're going to kick off with a few loss trends, specifically stemming from ransomware, privacy regulation, and third-party risk. The reliance on technology for day-to-day business operations continues to grow, and in turn, so does the demand and utilization of cyber insurance. So we can forward on to the next slide. Starting with ransomware, it certainly still remains a top threat in our space. As everyone on this call is aware, data and the value that it holds is foundational for life science organizations. Over 1,600 cyber events were notified to Marsh across our portfolio in 2024. Only 11% of those were actually associated with ransomware. That being said, these events are historically the most financially impactful when compared to other cyber-related losses. Ransomware attacks are increasingly damaging, with the growing sophistication of the attack vectors resulting in higher severity losses than that of the past. These events typically trigger every insuring agreement under the cyber policy, including first and third party. Taking a look at the next slide, we'd like to address the double extortion ransomware kill chain, which is a popular method of attack, whereby hackers carry out two separate methods of attack within a single perpetration. An example of this would be cyber criminals encrypting the data and also threatening to leak sensitive information if the ransom's not paid. This tactic has become increasingly common as it leverages the fear of data exposure to compel victims to comply with ransom demands. We've seen consistently higher ransom demands, although the amount paid is almost never the amount initially demanded. There's almost always opportunity to further negotiate. We note that selecting a strong broker and insurance partner specifically on your primary is imperative to ensure you have a deep bench with those familiar with these claims that can help support you in engaging with the right vendors for a more seamless recovery. The utilization of a broker can help in a lot of different ways. One being navigating business interruption claims, which can sometimes take months, if not years, to resolve following the actual outage or event. Our internal forensic accounting team at Marsh offers a template for tallying these costs associated with business interruption as a result of either a security or a system failure. Additionally, a broker can offer you assistance getting vendors pre-approved onto the policies, which is an essential step to prevent any delay awaiting insurance approval while simultaneously trying to work with your preferred cybersecurity vendors during an active incident. Moving on to privacy, on the next slide. Pictorially, as you can see here, the privacy landscape continues to evolve. By nature of your business operations in life sciences, there's a diverse set of data collection, and with that, an awareness that needs to be held with respect to the relevant regulation by state. 93% of our claims reported in 2024 still remain open. Privacy law can be partially to blame as there's new regulation that has not yet been tested and are still working through our legal system. I would like to point out the New Jersey Data Protection Act was officially signed into law on January 15th to join the 18 other states with comprehensive state privacy laws. Scott's going to get into this in greater detail later in the program. It's important to ask your organization, how are we managing biometric data, wrongful collection of data, pixel tracking, protected health information, etc.? The next question after that is, what regulatory laws are you then beholden to? To give you an example of how prolific some of these claims can get, the Biometric Information Privacy Act, or BIPA of Illinois, allows for fines of up to $5,000 per violation. The purpose of BIPA is to prohibit the collection of biometric data without prior written consent. I don't want everyone to get hungry. I know it's around noon, but I'm going to mention White Castle. They were hit with a $9.4 million penalty for collecting fingerprint data without written consent. This case actually led to an amendment to the law so that BIPA plaintiffs could only recover once for a single BIPA violation. Prior to that amendment, if I scanned my thumbprint 5 times, that would count as 5 different violations. Now that would only count as 1, limiting the damages the defendants are subject to paying. We made this point earlier, but the choice of a primary insurer or partner is essential. Some fundamentally do not agree with covering wrongful collection. That being said, understanding what data you have and choosing the right insurer with broad privacy cover will better support your recovery. And our third topic here on the next slide. As you will note, 60% of organizations work with more than 1,000 different third parties. As your organization continues to grow and expand, so does your exposure to third-party technology threats. The frequency of losses on our book stems from the third-party or supply chain risks. whereby a company's business interruption causes a domino effect, creating a correlated loss affecting multiple other companies. Big examples of this include the Move It, Change Healthcare, and CrowdStrike matters. Your life sciences organization are engaging with more third parties during the course of regular business activities than ever before. That can also come with access to one another's data. We encourage you to look at your third-party relationships and develop an understanding of a few key areas. One being, what is the criticality of this relationship to our business functions? What data do they then have access to? Once you figure that out, it's all about ensuring that they're embedded into your incident response plan. And then finally, regularly auditing them to make sure that they are up to par with your own cybersecurity standards. We encourage you to review your policy to ensure the coverage is responding to third-party losses that you don't have the ability to directly control. In summation, due to ransomware, privacy regulation, and third-party risk, cyber is becoming a more complex environment and causing a wider impact to all corners of your organization at any stage of the business lifecycle. My colleague Shane is going to provide you more information on how cyber should be contemplated in your broader approach to risk management.
Thank you, Catherine. And if we can move to the next slide, please. So, as Catherine eloquently laid out, the claims environment surrounding not only life science companies, but cyber risk in general is increasingly complex, right? And as a life science or as a company within the life science industry, your organizations are no strangers to complex environments, right? You operate in a complex business environment every day, regardless of where you are at within that continuum. Whether you're starting out with securing funding and capital requirements to fund your research, right? Whether it is the increasing regulatory scrutiny that is surrounding every aspect of the life science business, from products to production and so forth, all the way through companies that have multinational operations and supply chains, right? All of this is contemplated within cyber risk. And, it's important to partner with a risk advisor who has an intimate knowledge of not only cyber risk as a whole, but specifically your industry, right? And our goal here at Marsh is to aid our clients in all aspects of this cyber risk continuum that you see before you, and provide them with the tools and services necessary to accomplish the following, right? First and foremost, identifying cyber risk. If you can't identify your cyber risk, then there's nothing theoretically you can do about it. And we help our clients identify cyber risk, again, by leading with that industry-based expertise approach. Recognizing that, the manner in which each industry, and specifically life science, operates, but not only operates, but consumes technology, and the way technology interacts with your business as a whole, is vital to even understanding and beginning to understand where some of this cyber risk may lie. The second point is, once that cyber risk is identified, you have to be able to measure and analyze it, right? You can't transfer or mitigate or handle things which you cannot measure and analyze, right? And at Marsh, we leverage proprietary, purpose-built tools to help clients make informed decisions about how to transfer, mitigate, or where to begin in their cyber risk management journey. And then last but not least, in order to mitigate or transfer that cyber risk, it has to be adequately defined, as we mentioned. So that third piece is the transfer and or mitigation of that cyber risk. And our goal, again, at Marsh, is to curate an ecosystem of cyber risk product and services that maximize your return on capital, right? Especially in the past year of the economic environment, there's been increasing scrutiny on capital requirements and economic pressures, right? So it's important to understand that when you invest in one of these aspects of cyber risk, that they all play well together and that you are getting the most for your return. Next slide, please. Focusing in on the risk transfer portion, and in particular, that financing portion of when you transfer risk. Catherine mentioned several times that choosing or partnering with a primary insurance carrier is vital to that risk transfer process, right? And on the screen here, you see two generally highlighted approaches in which markets are approaching how they finance and deploy capital when there is a claim, right? So the first on the left, you see pay on behalf coverage. Now, what that essentially means is within the cyber insurance products, there are self-insured retentions, which I will equate very simplistically to deductibles, right? And essentially on pay on behalf coverage, that functions where dollar number one over the self-insured retention, right? So you as the client, the consumer of that product, have to out of pocket satisfy that self-insured retention. The next dollar over that amount, pay on behalf insurers will pay first party expenses, which are those expenses related with vendors handling or assisting with the response directly to the vendor. And that's extremely important distinction to understand because it helps with capital deployment strategies, right? Again, going back to companies that may be pre-revenue or early in their funding journey, this could be a vital difference between sustaining operations through a cyber attack all the way up to the difference of potentially not being here anymore, right? Or going financially insolvent. So under this coverage approach, right, for pay on behalf, the insurer, again, will typically make payments exceeding the amount of the self-insured retention. One thing to note in particular is that when you contemplate those first-party coverages, two coverages that typically cannot be afforded on this pay on behalf basis are ransom demand extortion payments, right? And there's a lot of legal rationale there and ethical, potentially moral risks associated with that some insurers generally are just not comfortable with, although that coverage is still typically provided on a reimbursement basis. And then business interruption losses, right? An insurer cannot pay your business interruption loss until it is complete, right? So by default, they cannot pay you out as you are experiencing loss. And as Catherine mentioned previously as well, this is an area of the policy that's important to have, qualified vendors and professionals to help you in quantifying such a loss. One of the other aspects that comes along with the pay on behalf coverage format is typically the trade-off there is insurers have typically more strict control over the claims process and vendor selection process. Now, as part of every cyber insurance policy, there are what we call consent requirements to engage vendors as part of, coverage under that policy. And, it's important to know also ahead of time which vendors you want to leverage in the event of a response. So there are these pre-approved vendors that each and every insurer has. And typically with insurers, again, that provide that pay on behalf coverage, they are less likely to let you use off-panel vendors, not to say impossible, but less likely due to how that coverage is provided. And it also enables them in many instances to provide that coverage. Switching gears, the secondary approach that is common in the market to this risk financing is the reimbursement approach. And that's relatively self-explanatory, right? The insured deploys capital to pay the claim and then seeks reimbursement from the insurer for covered expenses. And again, generally the reimbursement only applies to the first party coverages. Again, it's an important distinction to understand that cyber coverage as a whole contemplates both first party, which are expenses that would be directly incurred by you as the business, and also third party expenses, which are those typical liability expenses where there is typically some sort of litigation or allegation that subsequently needs or incurs defense costs. Contrary to the pay on behalf kind of model or claims model and vendor selection model, reimbursement insurers are generally a little bit more flexible when it comes to utilizing off-panel vendors, right? So again, as I mentioned, each carrier has their own set of pre-approved vendors. That's just a mechanism that is common in cyber insurance for those carriers to not only contain costs, but really understand the quality of those vendors that they're working with, right? One of kind of the hidden aspects here that is comes up often in client discussions surrounding vendors is it's not just about expertise, right? It's also about the administrative aspect or side of a claim where you may have a vendor who you work with on a regular basis who is very qualified in their realm, right? And is an expert in what they do when it involves cybersecurity. But they may not do a lot of work with cyber insurance carriers. And often there's a disconnect there or an administrative burden to overcome when seeking reimbursement, right? Things like invoicing become an issue. And, that's a very important discussion that we have with our clients on the front end to kind of mitigate any of those effects during a claim, which again, Catherine alluded to, can be complex and very expensive in and of themselves, right? Lastly, if we go to the next slide, an important contemplation when selecting the primary carrier to partner with for your cyber insurance, beyond kind of the nuts and bolts or four corners of that contract, right? What it says, beyond the way that the contract is intended to function from a risk financing perspective, is this idea of value, right? As insureds that purchase a product, you are entitled to kind of certain aspects of that product, which include inherent value. And one of the ways that cyber insurance carriers are currently differentiating themselves is by curating a portfolio of specific value-added cyber services, often at a discount or potentially even free, right? And this is extremely important because, an analogy I like to use all the time with my clients in these discussions is beyond the product you get and pay for with that premium, it's also important to think of that premium and your insurance policy almost like a Costco card, right? For those of you who aren't familiar, Costco, a wholesale warehouse, right? You pay for access essentially to discounted goods, right? The card you pay for in and of itself just gives you the access to then those discounted goods. And honestly, cyber insurance increasingly is functioning in a very similar manner. It provides, benefits such as access to a variety of quality vendors, right? For those organizations that may be less mature in their cyber risk posture, one of the first questions we get a lot is, in the event of a cyber incident, who do we call? Who do we rope in? Where do we go? We don't have relationships with incident response vendor firms. We may not have a relationship with a data restoration firm. And that is all curated on that previously disclosed kind of vendor panel, pre-approved vendor, right? So that's number one. Number two are access to those discounted cyber services and resources. Again, this is an increasing manner in which cyber insurance carriers are differentiating themselves in the marketplace beyond just coverage and price, right? You may be able to significantly impact areas of, let's say, the cybersecurity budget where things like a penetration test, right? An annual assessment that most, or if not all, clients should go through on an annual basis. Due to the way that these vendors are looking at the cyber insurance distribution channel, they're able to partner with these carriers to offer those same services that you may otherwise already be paying for at significantly discounted rates. And again, that's extremely important because when we think about the cybersecurity risk continuum and the increasing stretch on available capital, it's important to take that capital and those savings wherever you can and reinvest it into that life cycle to then continue to improve that cybersecurity risk posture. And last but not least, we have a subdivision of insurance carriers within cyber insurance, which we call or are known as insurtechs. And these are typically technology-based insurance companies. And what that means in a nutshell is these companies leverage, as part of their product, some sort of proprietary platform. And a lot of times those platforms are available to the policyholder to access and utilize for things such as vulnerability management, right? Understanding where, external vulnerabilities, if not possibly internal vulnerabilities, lie within your system. And again, this goes back to choosing the right primary carrier and partner on your insurance program, because you can significantly, again, impact the rest of your cybersecurity budget. If you are stretched for capital and you need, as part of your cyber risk profile, a vulnerability management tool, instead of going through the procurement process of all the different vendors and the ways they distribute and their pricing and understanding features, one method would be to leverage an insurance broker like Marsh to help you aid that kind of evaluation process through the lens of insurance. Typically we see a lot of clients have to maintain insurance for things like contract requirements or, to be able to do business with certain parties. And because that is an existing line item on your balance sheet, why not leverage it to maximize your saving and budgetary constraints elsewhere? And one of the ways that a good partner can help you do that is through, again, partnering you with the tools and services that help maximize the effectiveness of that ecosystem. That concludes Marsh's portion of today's presentation. I will now turn it over to Scott to discuss the specific NJ privacy statute that just passed.
If I can jump in, Scott, before we have a couple of questions, if you don't mind, Shane and Catherine. One question from the audience: does Marsh leverage industry standard cybersecurity frameworks such as NIST?
Yes, we absolutely utilize the NIST framework to inform our cyber self-assessment, which is our version of the cyber insurance application. It's widely accepted in the market because it offers comprehensive underwriting information for the insurers when evaluating a risk. And once the responses are inputted from your information security team, it then populates a score against the NIST standards. And it's an opportunity to benchmark where you are with respect to cybersecurity controls compared to that of your peers. So yes.
Great. Thanks so much for that, Catherine. Another question, if you wouldn't mind. I know, Shane, you were talking about the pay on behalf or reimbursement. Well, what's the market ratio, if you will, clients choosing X versus Y? What do you see out there?
So again, it's going to depend on a number of factors, right? The simplistic answer or response to that question is a lot of times for pay on behalf coverage, it is typically more available and more leveraged to those organizations that are, number one, just smaller in size, right? Have less of a severe, maybe, risk profile. And it also has to do with your current vendor ecosystem, right? So in order to qualify for insurance, as Catherine was mentioning, through our cyber self-assessment, we evaluate existing controls. So you have to have a baseline of controls in place. And the way I like to talk about it is, if you are, I will say, highly leveraged, right, from a cybersecurity standpoint, meaning you don't have a lot of internal resources or expertise to leverage for cybersecurity, and you rely on a lot of third-party vendors, that is something we need to know ahead of time and will help dictate what the best fit for that type of coverage is, right? So a lot of times we see clients who are, again, maybe less sophisticated in the response element, going for that pay on behalf coverage because capital requirements aside, going back to the claims handling process, that claims handling process essentially functions as your outsourced claims handling, right? So if you are one of those organizations that is sitting here saying, I know there's vendors, I don't know who to call, I don't know, typically who we would leverage in specific scenarios, maybe that pay on behalf coverage is a better fit for you because of that tighter control surrounding vendors and claims. And oftentimes you can lean on, Marsh and the cyber insurance carrier to identify who that appropriate vendor might be in a specific instance. And the next thing I'll just say on that is, it really comes down to also how your organization wants to deploy capital, right? Oftentimes, I know life science companies that are at, the beginning phases of their development life cycle do not have the capital to spend and to wait to get reimbursed for, cyber incidents, right? And Catherine went through some examples of numbers that can be pretty significant, right? And what we find too is that, conversely, larger, more complex organizations tend to have highly entrenched vendor relationships that they very much want to leverage in the event of a claim. And that is typically a better fit for that reimbursement kind of financing model where, as I mentioned, you get a little bit more leeway and freedom with the vendors you're able to leverage and kind of that claims process. And at the end, are able to seek reimbursement for that. So again, it's not a one size fits all. It's not a one answer fits all. It's really vendor ecosystem and capital management and what that means for your organization.
Excellent. Thanks so much, Shane and Catherine. Really appreciate it. Scott, we're going to turn it over to you, my friend.
Terrific. Thank you, Larry. And thank you, Catherine and Shane, for dealing with the insurance coverage issues. I have perhaps the more mundane responsibility now to talk about the Data Privacy Act, the New Jersey Data Privacy Act. It's brand new. As Catherine mentioned, it's just come into force. So it's kind of important to understand what your responsibilities might be under this new regime. Next slide, please. Because I'm a lawyer, I have to tell you, this is not legal advice. So please don't decide to do anything based on what I say here today. We will be happy to speak to you after this presentation. You will have my contact information. You can email me or call me, and I'd be happy to discuss things in greater detail. Next slide, please. So we currently have it, believe it or not. There is something called the New Jersey Identity Theft Prevention Act, which has been in force for a while. And it is what is generally referred to as part of the harm prevention-based approach to data privacy laws. You saw from Catherine's presentation that data privacy is fragmented among the states. Each state has its own data privacy paradigm. And when states started putting these statutes in force, the general approach was to prevent harms. And for the New Jersey statute, which again is still in effect, it basically deals with breaches of privacy, something called personally identifiable information, or PII. If there's a breach of privacy with regard to PII, you have obligations to report to law enforcement, to report to the victims, and you can be sued if you don't comply. That is overly broad in a nutshell what the NJITPA covers. But as you also probably appreciate, there has been a migration in thought with regard to how privacy should be addressed. And that pretty much has come about from our friends in the European Union. You're probably aware of the General Data Protection Regulation, affectionately known as the GDPR, which pretty much started the process of causing thought with regard to the fact that personal information is part of a human right that you can control and you should be able to control. And it is not merely just reacting to theft, reacting to unauthorized disclosure, but it is part of you that you should be able to dictate what happens to it on a going forward basis if that information is in the hands of others. Next slide, please. And also, as Catherine mentioned, in addition to the NJITPA, we now have this new thing called the New Jersey Data Privacy Act. It became effective a couple days ago. And critically, there is no indication quite yet that it will preempt or supersede the ongoing NJITPA. And conversation for another day as to how those two statutes will interact with each other. But it is something to be mindful of going forward. And typically, although the government has said that they're going to provide more guidance, they haven't done that quite yet. But the New Jersey Division of Consumer Affairs promises that sometime this year, they're going to provide some interpretive rules. So that will be helpful when that happens. When that happens, of course, we'll get further detail, but in the interim, we pretty much have to figure out what the best approach is given the language of the statute. Next slide, please. So again, we have a change in focus. We now have a regime with data controllers and data processors. And this again mirrors how the GDPR approaches personal information protection. So data controllers, no great secret, are the companies that own the data. They are the repositories of the data. They control the data and what happens to the data. Conversely, there are data processors. Data processors process the data. They manipulate the data. They do things to the data. And they are done at the direction of the controllers. A data controller can also be a processor, and oftentimes is a processor, but also data controllers will often retain third parties to process personal information for various reasons. So it's not necessarily the case that a data controller is a processor, but it is often the case that a company will wear both hats at the same time. And as you can probably appreciate, your obligations under this new law vary depending upon whether you are a controller or a processor. Next slide, please. So who does the Act protect? It is just consumers. So individuals in a individual or household context is what the statute says. So it's not entirely clear, but it seems that that does not involve employees or job applicants or third-party vendors or business-to-business relationships. So it seems to envision strictly consumers who are interacting with businesses for whatever reason and providing their personal information to those businesses in that business context. So it is rather narrow and subscribed by virtue of dealing, just in the consumer context. Next slide, please. And the information that is protected is now defined as personal data. Under the existing law, there's something called personally identifiable information, which is not exactly the same as personal data, which is why a discussion should be had as to how these two statutes are going to coexist. But personal data under the new law is broad. It is data that is linked or reasonably linked to an identified or identifiable person. And the New Jersey Division of Consumer Affairs provides some examples. Not surprisingly, home addresses, passport information, account information, but also be mindful, login credentials and web browsing history are going to be deemed to be personal data. But importantly, personal data does not include de-identified data. So if it's encrypted or aggregated, it does not fall within the law's protection. And also, it does not include publicly available information. So if you've lawfully obtained the information from a government source, or it's available online, or the consumer himself or herself has made it available, that does not count. It does not qualify as personal data under the statute. Next slide, please. But there are categories of data that are exempt, specifically called out in the statute, that do not fall within the new act. And there's a lot of detail that I just will not be able to get to, and I encourage you to take a look at the slides. You'll have a copy later, and I'll just go over these briefly. But for our purposes, you'll be happy to know that the New Jersey Motor Vehicle Commission can still sell your personal data. People are happy to hear that. But more importantly, for the purposes of the audience today, protected health information under HIPAA is not included within this statute. There are obviously, separate requirements under HIPAA to deal with personal health information, which are stringent, but to the extent that you have protected health information, it does not fall within the new New Jersey Data Privacy Act. And also, for the purposes of the folks in the audience today, personal data that is processed or disclosed as part of a HHS research on the protection of human subjects, whatever that means, that is exempt as well. So in the medical space, in the bio space, there are some specific carve-outs that are relevant to all of you in the audience. Next slide, please. So getting to the good part, who is required to comply? That is a very broad sweep. It includes nonprofits. Even though HIPAA data is not included, HIPAA covered entities are included here. Colleges and universities are included. And critically, unlike some of the other state statutes, there is no revenue threshold to trigger a violation. So broad reach of the types of entities that must comply. However, when you get down to brass tacks and try to determine whether you fall within that ambit, you basically have to conduct business in New Jersey or produce products or services that are targeted to New Jersey residents, which is just about every business that has a more than a regional scope. So again, the scope is broad. Just because you are a business located outside of New Jersey, if you produce products or services that are marketed, especially online, and are accessible to New Jersey residents, you probably are within the ambit of this law. But also, there is at least some de minimis exclusion here with regard to whether you are included. So in addition to being a New Jersey business or one that targets to New Jersey residents, you need to, during a calendar year, control or process the personal data of at least 100,000 consumers. So there's some measure of de minimis involvement there that may exclude you. Or you control and process at least 25,000 sets of personal data, and you derive revenue from that personal data. You sell it, you license it, is basically what this statute is talking about. So there is some threshold, and you may be small enough that you don't come within the statute because you don't process the requisite number of consumer personal data. But you should be mindful that as you grow and increase in your development as a company, you may trigger these compliance metrics. And critically, there is a carve out for processing personal data just to complete payment transactions. So if you are an online web-based business and you collect credit card information from people and sell your products by credit card, that doesn't count for the purpose of inclusion here. So it's more than merely conducting payment processing to trigger the the 100,000 consumer calendar year requirement here. Next slide, please. So the processors have their own obligations. And again, I won't belabor it in great detail. It's going to be covered by a written contract with the controllers. And the controllers will basically direct in the contract what the processors need to do with the personal data. So it will include how to process the data, how to secure it, providing information to the controller so the controller can meet its legal obligations. Critically, if the processor engages a sub-processor, what the sub-processor's obligations are, which will largely mirror what the controller dictates to the processor. And what to do with termination of the contract. What do you do with the data, deleting it or returning it to the controller? So the processor's obligations, again, broad overview, are going to be dictated by a written contract with the controllers. Next slide, please. The controllers really have the bigger obligation here. So what they need to do is multifaceted. The first important thing they need to do is to provide a robust privacy notice. So that includes what you probably expect, what data they're collecting, why they're collecting it, what they do with it, who they share it with, why they share it, but also providing the consumers with their rights that they can exercise with regard to their data, a contact mechanism to allow the consumers to reach the controller, and an opt-out process. There must be a robust and workable opt-out process that you as the controller provide to the consumer. Next slide, please. Furthermore, the controller has to collect and process the data only as reasonably necessary for the purposes of the privacy notice. No great surprise there. And then there's this new category of sensitive data, which requires affirmative opt-in by the consumer. So racial or ethnic, religious beliefs, and the other laundry list that you see here. More importantly, again, for this audience, mental or physical health condition, treatment, or diagnosis. If you're processing that type of data, it's deemed sensitive, so you have to get affirmative consent. Likewise, genetic or biometric data. Catherine mentioned BIPA, the Illinois statute that deals with biometric data. So if you're processing that type of information, again, sensitive, heightened affirmative consent is needed. Next slide, please. The controller also has to provide reasonable security. No great shock there. They can't process the data for discriminatory purposes, of course. And I don't have the time to go into it, but there are additional protections for 13 to 16-year-olds. If you have data from children of that age, that requires extra scrutiny. Again, as I mentioned, you have to provide an effective mechanism to allow consumers to revoke their consent, and requiring that you respond to most consumer requests regarding their data within 45 days. There are extensions possible, but 45 days is the target default. Next slide, please. Furthermore, just to make things more interesting, if you are engaging in a heightened risk of harm with your processing, you have to conduct something called a data protection impact assessment. So what does that mean? What is a heightened risk? Among other things, if you're processing personal data for targeted advertising, or if you're selling personal data, or if you're processing sensitive data, you need to do a cost-benefit analysis with regard to your intent to engage in that processing, the risks of it, the benefits of it, whether you can do it in a way that more adequately protects the data and proceed in a deliberate way with regard to this heightened risk of harm standard. And more importantly, it's got to be in writing, and the New Jersey Division of Consumer Affairs can request copies of your DPIAs. So you can't do a minimal job. It has to be a robust risk-benefit assessment with the focus on protecting the rights of the consumers. Next slide, please. Also, like the GDPR, the New Data Privacy Act has a recognition of all of these consumer rights, right to access, right to correct inaccuracies, right to demand deletion, right to obtain a copy, and importantly, to opt out of processing. So all of these new rights are now in effect for consumers. And if you fall within the ambit of the statute, again, you are required to acknowledge those and deal with them in a way that protects these rights of the consumers. Next slide, please. But there's also some carve-outs with regard to specific types of processing. So if you're engaging in internal operations, product recalls, etc., the act does not apply. Likewise, if you're complying with a government obligation, cooperating with law enforcement, defending legal claims, again, does not apply. Again, for this audience, protection of life or physical safety of the consumer, whatever that means, then the act does not apply. And likewise, very nebulous, if you're promoting public or community health, then the act is not applicable to the processing done for that purpose. Also, scientific or statistical research in the public interest is exempt as well. So again, I don't have the time to go over this in great detail, and I'm merely scratching the surface with regard to the statute. So I invite further questioning offline when we are done today. But as you can see, there's a lot of moving parts, a lot of uncertainty, and it's important that you at least assess whether you fall within the ambit of the statute, and if so, start your compliance journey. Next step, please. Enforcement, everyone's favorite. I guess helpfully, enforcement is limited to the New Jersey Attorney General, so there's no private right of action. So it does not provide enterprising plaintiffs' attorneys to file lawsuits, contrary, again, to the existing statute, which does allow a private right of action. Again, something that needs to be harmonized with thoughts of the specifics of your business. So no private right of action. The Attorney General will enforce the statute, but as you can see, violations can be stiff and they can add up. So 10,000 for an initial violation, 20,000 for each subsequent violation, and when you start multiplying that, you get to real money. And it's obviously important that you try to avoid having the Attorney General fine you for violations, which is why it's important to understand your compliance obligations under the Act. But there is a silver lining. There is a probationary period. So you have a year and a half basically to get your ducks in a row and to make sure that you have all of your obligations covered. So the New Jersey Division of Consumer Affairs must, it's mandated, issue a notice of violation if a cure is deemed possible, and you have 30 days to cure within this year and a half probationary period. So you have a little breathing room. It's not as dire as it might seem, but the act is currently in effect. It became in effect January 15. So if you've not focused on it, if you're not aware of the nuances, if you don't appreciate how it affects your business, it might be a good idea to bone up on it and figure that out. Next slide, please. That's all I have. Thank you for your attention. And I'll turn it back over to Larry.
Thank you so much, Scott. Really appreciate it. We do have a couple of questions from the audience for you, Scott. First one, with the life sciences industry so reliant on third parties, can you just offer some kind of best practice advice, not legal advice, but just good practice suggestions on how to look at third-party contracts, whether you're initiating a contract and the third party has to sign it, and in many cases for our pre-revenue friends and our early revenue friends, they're signing papers sent to them by bigger vendors. And how does a company in the life sciences industry protect itself so that whatever they sign, they're being true to their obligations for cybersecurity and data privacy in general?
A good question, Larry. I appreciate that, in the current context of many of the audience members, they don't have a lot of bargaining power. And when they are dealing with larger entities, they sort of have to take it or leave it. And that's, a problem because, again, if you are on the receiving end of a contract and an entity is sharing data with you for you to process it, you better be sure that you can meet all the requirements under the contract in this area. Because if you don't, the controller who shares the data with you is going to hang you out to dry. And among other things, you're going to be responsible for indemnification issues likely, among others, separate and apart from any attorney general investigation. So I appreciate that you may not have a lot of bargaining ability, but please be sure that you can comply with any contractual terms. If you are on the other end of the spectrum and you are engaging with third party, then you're sharing data with third parties. It helps to have a robust contract in effect which protects you and has stringent requirements on the processors that you're sharing data with. So I would suggest putting together a form which is robust and considering all of the various permutations under the law, I think, especially as it evolves, in order to protect your own interests when you are engaging third parties and sharing data with them.
Terrific. Thanks, Scott. Just another question. I suppose even with the best of intentions, where do you see most smaller companies, life science or otherwise, where do you see them fall short with trying to be compliant with either state cybersecurity law or, let's say, OIG, HHS type of industry standards?
Well, I think Shane mentioned it earlier. You're early in the process, early life science, you don't have a lot of capital, and you have to prioritize where you're spending the money. Unfortunately, data privacy often is at the bottom of the list, if it is even on the list at all. And I think, one key takeaway from my presentation and from, Shane and Catherine's presentation is, you can't relegate data privacy and data privacy risk, to a lower level functionary within your company. It has to be an issue that is considered within the C-suite. It has to be given prominence because the downside risk can just be so terrible. As Shane mentioned, it could literally put you out of business if you don't deal with it properly. So to summarize, Larry, life sciences, early stage companies, among others, need to step up and recognize that data privacy is a growing trend. It is something that needs to be addressed front and center. The appropriate resources, monetary and otherwise, need to be devoted to it, just to make sure it doesn't bite you in the behind and sink your company.
Well, that leads me to, I think, a final question we have, and I'm going to kick it back to Marsh, the guy, Catherine and Shane. So what do you say to people in our audience who are champions of all things cybersecurity, data privacy, but who have to go to board members or even investors to try to convince those folks that is a reasonable cost benefit priority? I mean, what would you say? Again, not legal advice, everyone on the call, but what might you say to someone at that level, why it is so important or how it's so important?
Sure. It's a really good question, and Scott touched on the importance specifically within the data privacy realm, but fortunately, we're seeing this sentiment be stripped away from the conversation just due to the growing sophistication of cyber attacks leading to a severe financial impact. When we think about cyber insurance, the immediate thought is a security breach and then a ransom payment. The scope of this coverage is far beyond just the cyber extortion costs. It extends to breach response, legal fees, regulatory fines and penalties, business interruption. That includes security and system failure, reputational harm, and data restoration and recovery, third-party liability, just much more. In addition to the covered costs, cyber insurance policies, as we've talked a lot about today, provide access to the discounted rates for the incident response vendors. So as more examples of cyber insurance claims occur, we have certainly seen an evolution in thinking whereby leadership is no longer viewing this as some ancillary coverage or something they don't really need to worry about, but it's an essential part of the due diligence process to ensure you're properly safeguarding the organization.
And if I can, Larry, too, I would just jump in and add, you mentioned in a question to Scott or a question to Scott about leveraging kind of third-party experts, right, to help with this. And it's exactly the same here, right? Our job as a cyber risk and cyber broker is to help break down those barriers and to get the decisions and risk to be understood by those stakeholders that need to understand it, right? It's something that Marsh is continually working on and investing in, is how do we structure responses, data, information, right, in a way that is going to be easily received by those that maybe don't sit on the front lines of this, right? When it comes to data privacy, when it comes to cybersecurity, understanding the big picture, right? We hear all the time from our clients, boards don't want to get into the minutia. They're not day-to-day experts. They want to know the big picture and the big picture impact on the business. And quite simply, I mentioned it, Scott mentioned it again, there are loss scenarios where, your business could easily be out of business if this is not transferred or managed appropriately. And so everybody, I think, universally understands finance and capital. So helping to put it in terms of that in the context of your business, right? If I might add, just as I wrap up here, one of the items that we see a lot of times is, from life science companies in particular, right? When it's around clinical trials or data that's being collected within whatever research you are doing, right? It's anonymized, it's encrypted. We don't have to worry about it. And, Scott went over the requirements for New Jersey, and that may or may not be true, but, we've also seen breaches like, forgive me, but what is it, 23andMe, where, you have protected health data that's out there. And that's, Scott went over one law as we saw on our presentation, there are 50 states with 50 different approaches to how they define notice obligations, how they define what protected data is, not to mention all of the federal laws intertwined with that, like HIPAA and things like that. So it's really understanding the landscape, number one, and then number two, just presenting in a fashion that is going to be easily understood. And we have found success that everybody understands numbers and finance. So if you can put it in those terms, it's typically impactful.
Fantastic. Thanks so much.
Larry, can I
Thank you,
just
Shane, Scott. Oh, I'm sorry. Go ahead.
follow up? Shane is absolutely right. Just because you are a company in New Jersey, that does not mean that you are not required to comply with the laws of the other 49 states if you direct business to residents in those states. And absolutely right, as Catherine mentioned, as Shane mentioned, the laws in those states differ, but unfortunately, you need to be in compliance with those states' laws to the effect that you touch residents of those states through your business. So it is a very fragmented landscape out there, and in addition, not to mention the federal laws, including HIPAA, as we've talked about as well.
Terrific. Thank you all. Thank you, Catherine, Shane, and Scott. I'm going to pass it back to Debbie Hart.
Terrific. Thank you, Larry, so much. Scott, Catherine, Sheen, well done. So informative, so interesting, and we very much appreciate your time and your support. To anyone in the audience, if we didn't, I think we got to all the questions that I saw, but if you have another one, please shoot it to us and we will get to it. Reminding all that a recording of this session will be on our website tomorrow at bionj.org. Thank you again to our sponsors, Mercer Marsh, McCarter and English, and Verve Group Consulting. If you aren't yet a BioNJ member, please reach out to either Sherry Hennessy or Danielle Sloboda to learn about the many benefits of membership at BioNJ. Their contact information is up on the screen. We hope to see you at future BioNJ events, including our annual meeting and innovation celebration on February 6th, where hundreds of industry professionals will come together to celebrate the innovation that's happening right here in our great state. Again, bionj.org for any information, including a full calendar of events. We ask that you please consider completing a very brief program evaluation, and you can use the QR code on the screen to do that, or just shoot us an email. Your feedback is really important to us. I'd like to thank you all for joining us this afternoon. I hope you enjoyed it, found it valuable, and I hope you all enjoy the rest of your day. Thank you again.